Now, the Senzo Meyiwa murder trial has resumed, with questions still being asked about the admissibility of the 2 of the 5 accusers' confessions. Brigadier Bongani Ginidinda was again cross-examined. He was asked if the accused were offered medical attention before taking their statements.
The doctor would have been a neutral person to examine accused number 1 and to confirm if there were any complaint of assault made by accused number 1. The doctor, meaning that by neutrality, I mean he was not part of the police if he was taken to the doctor. The doctor would have recorded the J88, record if there were any injuries, visible or old, and also any complaint that was made.
Yes, my lord. So I think one needs to look at the requirements of making a confession, and that it must be made freely, voluntarily, without any undue influence. Nowhere does it say the person must be taken to a district session as a requirement. Now, I know other police officers, perhaps they want to do that practice. It varies from person to person. Others will even want to take photos during the admission. But insofar as the requirement, you need to satisfy yourself that the person before you is willing to make this confession freely, voluntarily, without any undue influence, and he understands his constitutional rights. I was satisfied with that, my lord, when I referred him to Colonel Bolton. I do not think there's a provision that says he must be taken to a medical doctor before the confession is taken.
Right, let's unpack some of the proceedings in court. Joining us is Nthabiseng Dubazana, who's a legal expert. A very good afternoon to you, Nthabiseng. Thank you for your time. Lead investigator in the murder trial says there was no basis to refer allegations of assault by police on one of the accused to the police watchdog IPID. And of course, Advocate Zandile Mshololo has asked why the matter was not referred. What does this now tell us about the direction being taken as we unpack the line of questioning?
So when we look and refer back to how Advocate Mngomezulu was dealing with the examination in chief, or cross-examination rather, he was trying to show or infer that accused 1 and 2 had complained of being assaulted in one form or another. In fact, I think he talked about being tubed and all of those things. And they said in the line of questioning that accused 1 and 2 had informed the investigating officer of this situation. So the investigating officer has since denied all of these things. So the line of question that Advocate Mshololo is following, I believe, is similar to Advocate Mngomezulu, but she's trying to show that in order to show that the accused really gave the confession freely, voluntarily, without any undue influence, he ought to take an extra step as somebody who's a senior person in the SAPS, knowing the possibility that there could have been an assault or whatever the case may be, because he hasn't disputed that it does happen, that the SAPS do assault people in order for them to give a confession. So she is asking, why didn't you consider to do a due diligence over and above the minimum requirements, just to make sure that the confession that you're taking falls within the ambit of sections 217, 218, and 219 of the Criminal Procedure Act?
You make mention of Advocate Tulani Mngomezulu, but of course we know that he has been accused of a very serious crime and, facing serious charges when it comes to attempted murder. Where does this now place him in this murder trial, which has suffered a lot of setbacks?
Well, at this stage, it ought not to affect anything. He has not been convicted of any crime right now. But if I were in his shoes, I would most likely withdraw as the current attorney of record or counsel of record in this situation, because it may mar the situation, and, he may not be viewed as somebody who is competent to continue with the trial and all of those things. But for now, he is not being found guilty of any crime, so it ought not to affect the manner in which this matter is going.
So what more can we expect as Advocate Mshololo continues with her cross-examination this afternoon?
So I think she concluded just before we started that we are now dealing with re-examination. But I like the trajectory that she was using when she was asking her questions, because she was basing it on a very old case back when we had the interim constitution, wherein the court stated that a suspect is equated to an accused person. So upon you arresting a person, you need to read them their rights. They should know that whatever that they're divulging to you, they know what the consequences of that are. So the IO who's now in the box to give the evidence, I forget his name unfortunately, he has stated that no, on the piece of paper, it's called the right form, and also the warning statement, there is no requirement for us to write down that we did X, Y, and Z. It is done when they're in the field, but then that's about where it ends. And that's where the problem is. 90% of the time, we find that when a person is still a suspect, when they are arrested, they are never read their rights. They give information, whether it's in the warning statement or voluntary, or not really voluntarily, but they give a statement of what happened to the person who's arresting them without knowing the consequences thereof. So the manner in which you made the IO go through the warning statement and understand what it means, that at every stage that you interview a suspect, not an accused person, you ought to make sure that they understand what these rights mean, and this was not followed. So that case that I'm speaking about, that was under the 1994 Constitution, the interim constitution, said any evidence acquired before an accused person has been explained to his rights, all that evidence is inadmissible in court. So that's where she's going with all of this.
So as the court hears this trial within a trial to determine the admissibility of the two confession statements, what challenges will it continue to grapple with?
One of them we just spoke about now, whether or not the constitutional rights of the accused were detrimented or prejudiced against them and all of those things. But I think the main thing was during Advocate Ngomezulu's cross-examination. The trial within a trial deals only with admissibility of evidence, right? Which is the statement that we're dealing with, the confession. But what he did is that he brought in the merits of the main trial within this cross-examination under the umbrella of a trial within a trial. And I think he was warned not only by the presiding officer, but by Advocate Baloyi to say, if you want to hand in certain information as evidence in the court, please be aware it may act as a detriment to your client going forward. Because let's say, for argument's sake, that this trial within a trial ends wherein the confession is not accepted by the court. It means even the evidence that was handed in during the trial within a trial is not going to be considered. So it will be as if he never laid evidence pertaining to, for example, that Kelly Kumalo had hired Inkabi to assassinate the deceased, all of those things. So I think the line was a little bit blurred in terms of how to deal with a trial within a trial, and that is where the court is going to have to try and discern in a very objective way how to deal with the situation it has.
Very insightful indeed. Thank you for your time. Nthabiseng Dubazana, who's a legal expert, just weighing in there on the Senzo Meyiwa murder trial.